Farris.
Speaker. What happened to the workers at P&O is one of the most disgraceful examples of industrial practice in my adult lifetime. It speaks not actually to the weakness of our employment laws, but to their strength, that the Trade Union and Labour Relations Consolidation Act and the Employment Rights Act has, for the last 30 years, rendered a case like this so rare that we're having a debate about it in Parliament today. What is extraordinary about this case is not that the laws didn't exist, but that P&O, or DP World, thought it could break them and do so with impunity. And let's take a moment to state what they are. My honourable friend, the member for Bexhill and Battle, spoke about Section 193, the statutory obligation to inform the Secretary of State 45 days before any proposed redundancies would take place, broken. Section 188, the duty to consult 90 days before any dismissal takes place, broken. Of course, then under Section 86 of the Employment Rights Act, duty to give notice. Section 98, unfair dismissal, broken, broken, broken. The question for this House is why DP World thought they could do that, and the issue, I think, is enforcement. It is true that failure to notify the Secretary of State is a criminal offence. I can think of no example in my lifetime of where any criminal proceedings have been brought against any employer anywhere in the United Kingdom ever since the Act was passed in 1992. The reality is that a breach of this nature is so rare that parliamentarians probably haven't had to worry about it, but we haven't insisted on it nonetheless, and I was very glad to hear the Secretary of State say that he would be looking at enforcing Section 194 in this exceptional circumstance. I will.
I'm very grateful for my honourable friend giving way. Section 194 is a summary offence only, punishable by a level 5 fine. But the Secretary of State referred to another section which gave rise to an unlimited fine. Does my honourable friend agree that in a circumstance, such an extreme circumstance as this, the egregious nature of the sackings and the number of people involved would be gross aggravating factors when considering the size of an unlimited fine?
I thank my honourable friend for his remarks. I think that's correct, and I think that's what the Secretary of State was alluding to. It's also the case that DP World have obviously concluded that they would rather pay a severance payment that takes into account the 90-day consultation period and the notice period and the redundancy period, and that is less hassle for them than going into a consultation for 90 days with the RMT and facing strike action. So, I'll come on to my solution in a moment, but I want to briefly address what members on the other side have said about banning fire and rehire. The member for Ogmore, the member for Sefton Central, said that the honourable member for Brent North's commendable private member's bill would have banned fire and rehire. With great respect, I refresh the House's memory as to what he said about it, and I checked Hansard. I have no intention of this bill of banning, and there is nothing in this bill that would ultimately ban fire and rehire. There's an important reason for this that I will come on to in my speech. I'll answer the point for him. The reason that it wouldn't ban fire... I will give way.
I'm grateful to the Honourable Lady, and she's absolutely correct that there was nothing in my bill that ultimately would have stopped fire and rehire situation, and that was with full cognizance of the 22 unions that supported the bill. But as she knows, there were measures contained within my bill which would have prevented this situation.
Honourable Lady answers. I can see that there are important points being made backwards. If the Honourable Lady could just resume her seat for a minute. But it would be helpful, in order to make sure we can get everybody in, that if there are interventions, that we try to stick to the original time limit. Otherwise, some people won't be able to get in. Laura Farris.
I thank the honourable member for his intervention. He will know that the reason why you don't want to legislate to ban fire and rehire is because you'll end up with more dismissals from the decent employer who's under extreme financial stress. As the honourable member for Bury South put it when he spoke in that debate, it must be an absolute last resort. Fire and rehire must be an absolute last resort, and we on this side of the House have always agreed with that proposition. The position that we have always had concerns about is that is that the bill that the honourable member was proposing risked more job losses, not less. That is the prevailing view at the Employment Law Bar. I spoke to John Bowers QC yesterday, one of the great trade union lawyers of his generation, and his view is that you are jeopardising jobs with this bill. If I'm incorrect on that, I would ask the front bench to address in their closing submission why, as a matter of law, he's wrong. But it's true to say that any provision that says, as a matter of fact, that sets conditions that were so onerous as the proposed 187B did, that any failure to consult or to disclose everything, no matter how sensitive, could lead to unlimited damages, would not lead an employer to dismiss rather than to renegotiate employment terms, is fanciful. The bill risks more job losses, and we know from the bitter lesson of P&O that if employers can take shortcuts and if they can take the easy option, then they will. This bill risks more P&Os, not less. I have said previously, though, that the answer to this lies in the ACAS Code of Practice. Parliament intended it to do so. Parliament intended it to do so through sections 203, 207 and 207A of the Trade Union and Labour Relations Consolidation Act. It conferred a power to the Secretary of State to pass codes of practice with financial penalties, and I have said repeatedly in this House, and I respectfully ask the Minister not to make me do it again, that that is the correct mechanism. What it does is it turns the screw on the unscrupulous employer in a way that nothing the opposition have suggested does. It is also consistent with the prevailing view on the excellent ACAS consultation that was consulted last summer, when a number of points were made as to how, by practitioners, including how it could be demonstrated that it was a genuine last resort, consultation being one aspect of this, but also the employer being required to demonstrate that they had considered other alternatives. The other thing I would suggest, which I think is imperative, is a new form of injunctive relief, which is not available to the claimants here, which would allow the High Court to mandate the employer to impose a 90-day consultation period, which I think would address some of the problems. But again, it could go into an ACAS Code of Practice. We don't need new laws. We need to turn the screw on the exploitative employer by hitting them with penalties that will stop them doing it in the first place. We can talk in the language of emotion and recrimination.
Order. Order. Barry.